Pressed the let's go live button. So let's wait for the stream to fire up all across the fruited plain of the internet. We're talking about YouTube. We're on Rumble. We are natively streaming on Locals now. I mean, if you want to just watch on Locals, it's native there, baby. And that's where the after party is. We're also on Twitter. We're also on Facebook. And so wherever it is you're tuning in from, we like to make sure that the tubes are working. And it seems like they are. So let's jump into it, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live. My name is Robert Gouveia. I am a criminal defense attorney at the R&R Law Group located in the always beautiful and sunny Scottsdale, Arizona. And today, my friends, we are talking about some election business. The headline on the thumbnail is Monitor. That's right. We're talking about election monitoring. One of the segments we'll get to today is the DOJ is now, kind of getting involved in this. You may have seen some imagery of individuals in Arizona sitting outside ballot boxes, drop boxes, and that's going on. The DOJ is very unhappy about that. And so we will go into that story today because there was an order that came out from an Arizona federal judge said, actually, they can do that. What they're doing, it's free speech. You have free assembly. You can go out there and you can participate and watch all of this stuff happen. And the judge said that they can do that. But the DOJ said, watch it, buddy boy. We don't want you monitoring anything. We do the monitoring around here. And if you even think of getting involved, well, we're going to have problems. Marc Elias, somebody we've talked a lot about, has said that if they catch you doing this or something, I'm not exactly sure what his threat is, but he says they're going to sue you. So we're going to check in on that story, of course. Election is just a short 7 days away. Yeah, that's right. Holy moly. Yeah, it's coming up right around the corner. And so we've got some election business to attend to. But there was a big ruling came out from the Supreme Court. Well, that's not that big of a ruling. It's a good ruling for Trump, but it is a big one because the Democrats were very excited to get their meaty paws on Trump's taxes, but Trump filed an emergency request last night. It hit the Supreme Court docket. Judge Roberts, we woke up today, he said, granted. So he said, Democrats over at the House Ways and Means Committee, you are not going to be getting these tax records that you have been salivating over for some time, pending further review. And you people have to draft up a response and get that submitted later on in this week. So, of course, another avenue that we'll uncover from Donald Trump. He's getting a legal onslaught from multiple different venues, and we've been covering them all. And so we have a little bit of heavy lifting on that first segment here today before in our third segment, we'll talk about the incoming red wave. You see that there? Yeah, that's about what it's going to look like. And that's a imagery from The Shining, which is something that was shared by Joe Rogan. He also used that imagery. He said, it's going to be a bloodbath, just like that. And we're actually seeing some of the polls tightening up as usual. It's very convenient. When the election gets closer to the deadline, suddenly everybody comes crashing in and say, oh, yeah, looks like the Republicans may actually win. Very, very convenient. RealClearPolitics, they came out. You take a look at this. They're saying Republicans looking like it might be a 54-46 in the Senate. Woo, boy. Yeah, that's sort of looks like that hallway for sure. And then you also have 538 is sort of coming to terms with reality. And it's going to be some interesting results here very soon. We're going to check in with Joe Biden. Of course, yesterday we spent a lot of time talking about Pelosi and DePapi, and we read through that criminal complaint at length yesterday. But today we've got Joe Biden in the White House. They are responding to a lot of the to the developments of the story, and you can see what the heck is going on with this here. Okay, so there that is. We have some loaded up here clips. We've got Karine Jean-Pierre, who we're going to check in with. Biden is talking about his son dying in Iraq, which was news to me. I didn't know that happened. He said that he cut the deficit in half and that he wants to unite with Republicans. If we could only unite, then that would be a nice way for America to improve. And he basically says that he hopes the Republicans stop being so stupid so that they can, in fact, unite. We've also got a clip from Ted Cruz. He says, if they win, baby, if you put the Republicans back in charge, there will be some serious oversight and some aggressive maneuvering from the Republicans. We'll see if that happens. But as you can see, my friends, boy, we have a lot to get to. And if you want to be a part of the show, the best place to do that is over at our community. It's called watchingthewatchers.locals.com. You can see it right there. Head on over there. We've got Rolf Epp is here along with John Allen. We've got Jason on Blast. Lilu Dallas Multipass is also over there at watchingthewatchers.locals.com. We have our morning walk and talks. We've got Uncle Shane. We have many others. We have an awesome community where we share stories and stuff throughout the day. We also have the after party. When this show ends here, wherever you're watching it, it's not over. We just go and we just, we have some other stuff to attend to. And if you want to join us, it's at watchingthewatchers.locals.com. Also, I am a lawyer. I mentioned this at the start of the show. Over at the R&R Law Group, we're located in Scottsdale, Arizona. If you go to our website, rrlawaz.com, you can click that button. Schedule online. You'll see we can help you with any variety of criminal cases in the state of Arizona. And they are unfortunately common. People travel through Arizona. The weather's beautiful. We've got weddings and stuff going on. And if you get in trouble with the law, we are the law firm to help. We have a mission to help good people charged with crimes find safety, clarity, and hope, not only in their cases, but beyond that, in their lives. And your referrals keep us busy. So thank you for sending them over to us at 480-787-0394. Uncle Shane says it's 120 degrees there. No, it's like 78. It's like 76 right now. It's gorgeous out. It's jacket weather for people like me. It's like, woo, what is that, 74 degrees? Woo, better bundle up. Woo, it's Arizona. I'm just kidding. All right, but it's kind of. All right, so let's get this queued up so that we can dive into it, because we do have some heavy lifting on this one. Donald Trump had I think it's 28 pages or so. Well, let's just get right to it, shall we? Donald Trump has a victory at the Supreme Court of the United States. Democrats for a long time have really, really wanted his tax records. They want to get their hands on him so that they can do something with him, maybe charge him with some sort of tax fraud crimes or refer this over to the DOJ to open up some other avenue of investigation. Or maybe it's just to say he's not nearly as rich as he says he was, and so on and so forth. Who really knows? But they wanted this stuff badly, and since they're in charge of most of the government now, they have been able to get a lot of this litigation up off the ground and been able to make Trump's life pretty miserable. The House Democrats created a body called the House Ways and Means Committee. We've seen all sorts of committees in Congress where they just go after their political enemies, essentially, is really what this is boiled down to, at least in the last several years. And they have been fighting for Trump's tax records. They say the IRS has to give it to them because they are a legislative body that is properly investigating an issue, which is an outgoing president. And so we can see we've got two items that we'll take a look at here today. First, the emergency request that Donald Trump filed. You can see that is going to be the crux of this. And then we'll have a very short order that came out from the Supreme Court, Judge Roberts presiding. He is the chief judge. And because this came up through the DC Circuit, it's now going to fall on his lap. So let's start with the original filing, which was something that came from Donald Trump. You can see this here. Filed in the Supreme Court of the United States. The applicant is Donald Trump and everybody else associated with Trump. Trump's Trust, Trump Holding, all the different LLCs, along with the different corporations that Trump is involved in. Now, it's versus the United States House of Representatives. That's Congress, the Committee on Ways and Means, and the Treasury, the IRS, and all of those different agencies are responding because this is about Trump's tax records, his financial material. Now, this is on application for a stay in the Court of Appeals, the DC Circuit. Remember that because this is something taking place in Washington, Congress is saying we need this over from the IRS and the Department of Treasury, and they're fighting over this in Washington, D.C., so the D.C. Circuit Court is going to hear it, and this has already gone up through several different levels of appeals. The D.C. Circuit goes to the D.C. Circuit Court of Appeals, and they're appealing from that, which Trump lost. Remember, at the Court of Appeals, Trump actually lost. The court said, oh, yeah, you're the Congress. You can get whatever you want. By the way, this is Donald Trump. Who cares about him anyways? Just take it. And now Trump said, hold on a minute, this is not right, and made this emergency application for a stay. You see it titled here, Trump filed the emergency application for stay of the mandate pending the filing and the disposition of a petition for a writ of certiorari. And this writ of certiorari, this is the big filing, right? This is the big thing that we normally will look at on this. We'll say, wow, okay, this is the new application to the Supreme Court. It's like 120 pages. And it's a big, big, hefty, meaty chunk of legal paperwork that we have to read through because there's a lot that goes into it. But this is really happening quickly because, boy, that 11th Circuit or the DC Circuit just issued a ruling. Court of Appeals gave it to the government. And now Trump is saying, we have to get this done right now. So it's an emergency petition application, and you can see it's filed by several different attorneys, all listed here. As we proceed through the application, we notice that the parties to this are, of course, Donald Trump and everybody involved, along with the Committee on Ways and Means, Department of Treasury, and others. The two proceedings that took place before we got to the Supreme Court, they're saying it took place here, was in this litigation, which was decided by the DC Circuit Court, and then we see another judgment was entered on December 14th. They say there are no other related proceedings, and they're just giving us the details there. Rule 26, we have the table of contents. We're going to fast forward through all of this stuff, but you can see they give us 4-part analysis, 4 different paragraphs, arguing that the government is entitled, that Trump is entitled to a stay. Trump is demanding that the transfer of the documents of the tax records do not go from the IRS to the House Ways and Means Committee. So let's take a look. Once we fast forward through the authorities at the application, Trump's lawyers write, Dear Honorable John Roberts, Chief Justice of the Supreme Court, this case raises important questions about the separation of powers that are going to affect every future president. The only way to preserve these certiorari-worthy questions, meaning that we can get to you, Supreme Court, and you'll actually listen to us, and to avoid causing applicants like Trump irreparable harm, is for this court to grant an administrative stay by Wednesday, November 2nd. That's 1 day away from today. And guess what? They got it. Supreme Court did grant the stay, which we'll take a look at shortly. And then to stay the issuance of the mandate pending the filing and the disposition of a petition for a writ of certiorari. They're saying, Judge, we need you to just temporarily put this in place because we are putting together this whopper that we're going to send in that's going to give a lot more meat to the bones of our argument. If the court wishes, it could also alternatively construe the application as a petition for a certiorari and grant review. In other words, if you're not going to grant this immediate stay, then just consider this our whole application. They're asking for kind of the same outcome. They're giving the court 2 different roads to get there. They write, the House Committee on Ways and Means, through its chairman, Richard Neal, representative, has requested from the IRS 6 years of tax returns and related files for President Trump and 8 of his business entities. It's a lot of records. As justification for these records and these papers alone, the Democratic committee has offered only an interest in studying the staffing and the funding of the IRS audit process for presidents and vice presidents. So they're just like curious. Oh, I wonder what it's like to go and investigate a president. Well, we're just curious about the audit process. Yeah, right. This case is about whether that bare statement alone as a matter of law, and even in the face of extensive evidence of pretext, satisfies the test that this court, meaning you people, announced in a previous case, Trump versus Mazars. And remember, this case was back in 2020. So not that long ago. Trump's lawyers are saying, Judge, we've already had to settle this issue back in 2020. Let's continue. Trump's lawyers say, the Democratic committee's purpose in requesting Trump's tax returns has nothing to do with funding or staffing issues at the IRS, and everything to do with releasing the president's tax information to the public. Business entities aren't even the subject of the program of the committee's professed concern, nor were the requested individual returns from years outside of Trump's tenure in office. And although every president and vice president since 1977 has been subject to the Presidential Audit Program, see Appendix 3, the committee sought records related to a single individual, Trump. That's weird. It's like they're singling him out. Oh. Trump says, on top of this objective mismatch, Chairman Neal and Speaker Pelosi in their on-the-record statements, as well as statements by other officials involved in making the request, evince quite a different purpose: exposing Trump's tax information to the public just for the sake of exposure. In other words, there's no basis for this at all. They say they need this because they're legislators. And what do they do in Congress? Well, they study issues and they bring in a bunch of people in front of committees and they put them about a round table and they pretend to ask them questions that some poor intern drafted up for them, and they put it in a big fat binder so that these bureaucrats can just read from them. And so that's what they're doing. They're saying, well, we need to investigate presidential tax implications. And so why don't we start with Trump? That sounds good. A panel of the D.C. Circuit, Trump's lawyers say, however, held that all evidence of pretext, meaning an excuse, right? In criminal law, we talk about pretextual stops. This is when a police officer stops you for basically a BS reason in order to find a bigger crime. So they'll stop you for a broken taillight. Oh, you got a broken taillight. It happens to be 2 a.m. and you happen to be leaving this area where there are drugs being sold. And so I'm just going to go ahead and stop you for a taillight, knowing that they're going to go and it's going to be used as a pretext to get into your car and find a bunch of other stuff. And so you might agree with that or disagree with that. I happen to disagree with that, but it's something that exists. Police just make up stuff all the time. I digress. They say that all of the evidence of pretext, which the district court called impressive and troubling, is insulated from review. Okay, so this means that if the Democratic committee actually wants to get Trump's record, just like a police officer might actually want to get a drug crime or actually arrest somebody for transporting narcotics, they'll say, well, we're just going to stop you for that taillight, but it's going to get us a much bigger fish. Same thing here. They're saying, oh, no, we don't want Trump's records. We just are looking at audit procedures. Yeah. For, presidents. Yeah, that makes sense. Totally benign, totally inconsequential. Nobody even cares about it. But it allows them to use that as an excuse to go do whatever the hell they want. And the district court said, well, yeah, I mean, it is impressive. Like, you are kind of skirting that one pretty nicely. It's also troubling, but it is insulated from review. The panel at the other court concluded that the bare statement of purpose on the face of the request satisfies the test announced previously by the Supreme Court. If they put in there in the statement, they say it's for a legislative purpose, then they can get whatever they want. We're Congress. We said we're doing it for a good reason, okay? So just let us do that. And of course, the D.C. Circuit Court said, yeah, let them. Trump's lawyers say there is extensive evidence that this stated purpose was only a pretext. And they're saying, Supreme Court, you said that's a problem because you can't just do stuff on pretextual bases. Trump's lawyers argue this error will hamstring the president in disputes over any future demands for information. And if allowed to stand, it will undermine the separation of powers and render the office of the presidency vulnerable to invasive information demands from political opponents in the legislative branch. Review is of the utmost importance, and the court should preserve its ability to grant it, not just for one, quote, particular president, but also for the presidency itself. Which is absolutely true. Just apply the same standard to any Democratic president. Wouldn't it be insane if a Republican committee could just go in there and just say, well, we can do whatever we want and demand anything that we want if we just, with the stroke of a pen, say that we can do that. It's a legislative purpose, right? That would be nuts. And honestly, the Republicans, if this stands, right, can and should do the exact same thing to the Democrats. Even though I may disagree with the tactic, if the Democrats are doing it, Republicans got to do it as well. It's for the sake of their survival. And so what they're arguing here is this is going to really shatter how all of this works. You better accept this because it's not just about this particular President Trump. It's about the entire institution. Trump's lawyers say the court will only have a chance to consider granting review if it stays the lower court. If it doesn't stay the lower court, guess what happens? The tax records get transferred and this whole issue becomes moot. The government has said it's going to release the requested information to the committee without delay when the mandate issues, currently scheduled for Thursday, November 3rd. So Trump's lawyers are saying, look, Judge, I mean, like it's got to be Wednesday, Tuesday, or just forget it. Because the government is scrambling. You've got a bunch of people over there at the Department of Treasury that said, holy crap, the DC Circuit just gave us this opening. They parted the legal seas. We better run through it before it closes up and swallows us whole. And Trump's lawyers are saying, Judge, you better do something about this because it's going to be too late. Applicants sought a stay below while the committee, meaning Trump wanted you to put a hold on this, while the committee sought an immediate issuance of the mandate to moot the case on the spot because they are snakes. They're trying to get it through before Trump can appeal it. They go, holy moly, if the Supreme Court stops this thing, we can't get him out. But if they can just eke it out, that's why John Roberts, and this was filed on Monday. The order came out on Monday. John Roberts said, stayed, you got it. The Court of Appeals denied both motions. The committee now opposes a stay of any length because they want those to leak out, including an administrative stay. The Department of Justice and the government, they oppose a stay pending certiorari, but takes no position on an administrative stay. Now, they give us a little detail on the lower opinions and the jurisdiction. And we've covered most of that. But let's get into the background and the procedural history. Trump's lawyers write, Democrats made a national issue of Trump's tax returns. And they did that back in 2016. And for the 2 years before he became chairman of the Ways and Means Committee, then ranking member Neal sought to expose Trump's tax returns to the public without offering any legislative purpose. To the contrary, Neal openly stated that he wanted to disclose the tax returns, quote, to enable the media to sift and sort them. And so the public could see whether he uses tax shelters, loopholes, and other special interest provisions to his advantage. Cited. And those are quotes. In a published report, Neal wrote that, quote, the public needed to see Trump's returns to get the clearest picture of how much he earns, how much tax he pays, his sources of income, whether he makes charitable contributions, whether he uses tax shelters, loopholes, or other special interest provisions. That doesn't really sound like it's about a legislative purpose, more so than it is about skewering Donald Trump. It's not about an overarching program of presidents. This guy hates Trump. He's got TDS with the rest of them. Minority Leader Pelosi, quote, called it one of the first things that the Democratic majority would do. And Neal affirmed that Democrats would, quote, force disclosures, saying that Democrats had voted again and again to release those documents. They hate the guy. They just want to take him out. Democrats took control of the House in 2019. Chairman Neal did not disavow his purpose, but he warned his Democratic colleagues not to step on their tongues to avoid undermining their case. When this moved forward, Speaker Pelosi, who approved Chairman Neal's ultimate request, said, quote, I think that overwhelmingly the public wants to see Trump's taxes. They want to know the truth, and they want to know the fact and that he has nothing to hide, is what Pelosi said. Spokesman for Pelosi later told the press, quote, all roads lead back to Trump's tax returns, which would show his improprieties, potential tax evasion, and violations of the Constitution. It's about Trump. It's not about audits. It's not about IRS procedures or how they audit outgoing officials. In April 2019, Chairman Neal formally requested the tax returns of Trump and 8 Trump entities, along with audit information and IRS records. Chairman Neal claimed that he needed these materials, Chairman Neal said, to study the extent to which IRS audits and enforces of the federal tax laws against the president are conducted under the manual and mandatory examination of the IRS manual. But we also see that another representative named Pascrell explained that Neal's rationale was chosen according to counsel as the best way to make sure we got the returns. Okay, so in other words, this guy just took this sort of strategy to his lawyers, and his lawyers said, well, we can't make it about Trump. We have to really expand this to make it about audits in general. And then that's going to suffice. That's going to meet that legislative purpose, and that's all we need. Chairman Neal himself acknowledged that he had strategically, quote, constructed the best possible case to stand up in court. His words, not ours. Saying, we're going to do everything we can. Okay, it's a bunch of cops waiting around to entrap you and then using justification in order to get what they want. They're just saying, well, we're on Congress. I mean, we can think about laws for whatever. And Trump happens to be in the purview of this hula hoop. Trump's team says, indeed, in the 3 years of demanding disclosure of President Trump's tax returns up to that point, he had never once offered the IRS's mandatory audit process as a rationale. Okay, so this guy says, it's about Trump, it's about Trump, it's about Trump, it's about Trump. The Democrats win in Congress. Suddenly, it's about an audit. Oh, I guess I can't really go after Trump, so we'll just make it about an audit. Isn't that convenient? As a supposed attempt to study the presidential audit program, the committee's request was far off target. Trump was not subject to that program for half of the tax years in the initial request, and none of the business entities in the request have ever been. The request also purported to study a program that has covered every president and vice president since 1977 by requesting information related to a single individual. Interesting. Yeah. They're studying all these presidents back to the 1970s, but they don't need any records for them. They only need Trump's. It called for files from audits that were still ongoing, and it called for the underlying tax return information, which has no relevance to a legislative study of an auditing process. Right? Auditing process means we're talking about the process, not about the material. Meanwhile, committee members like Neal repeatedly contradicted their requested stated purpose. They continued to describe the requested purpose in terms of exposing Trump. It's not about passing good laws. It's about exposing the president. Saying a proper request would allow us to do our job. And to any extent that they discussed the IRS audit process, they did so in law enforcement terms, expressing their desire to audit President Trump and uncover evidence of illegal conduct. They're turning this, just like the J6 committee, into a pseudo-judicial or prosecutorial body where they can now say that we're going to use our legislative power not to go study the law or study the situation and pass laws, but to go and expose their political opponents. Now, the J6 committee was illegally constituted, still is in my opinion, and it is obviously partisan and political. It was set up for that. This is just an ordinary committee that is just ordinarily running, the House Ways and Means Committee. It's not going to expire. It's not going to sunset. This is just what they do. And you can see that according to Trump's team, they're saying that they have gone, and it's pretty good evidence here, it's their own statements. A press release issued the same day, Chairman Neal said that the request would help the committee determine whether President Trump is complying with the tax laws, right? That's kind of what a prosecutor does. You have a police, they go investigate a crime, they turn it to a prosecutor as their probable cause. Yes, you charge them. That's the executive branch. You don't have Congress running around investigating people to determine whether they comply with the law. That is clear separation of power, but these Democrats are using this language in their own House committees. And throughout 2019 and 2020, Representative Pascrell and other committee members continued to say that the committee needed Trump's tax information, quote, to see how far his crimes go. Probably a quote on MSNBC or something like that. We got to see how far his crimes go. That's not your job, Representative Pascrell. You're a representative. You're not a prosecutor. We know that you think you might be and that you're using this to fundraise and to continue to win your district. But you're a legislator. This is for the DOJ and the IRS. If Trump violated the tax laws, that's on them, not on you. The committee's improper purpose, they say, was not lost on the executive branch. And if we rewind the clock back to our social studies and civics classes, we remember that we have the three branches of government and they're co-equal. And that the three branches are supposed to, when another branch is encroaching on their territory, they're supposed to elbow them back over the line and say, that's our responsibility. We have that power, not you. So if Congress is acting like the DOJ, the Department of Justice, which resides under the executive branch, if Congress acts like the law enforcement agency that goes and polices all of America, including conveniently their political enemies, isn't that a little bit of a problem? And shouldn't the executive branch tell them, get back to your side of the line here? We have the FBI, we have the IRS, we are the executor of the law. That's why we're the executive branch, and leave us alone. But the executive branch has not done that. They have been totally willing to acquiesce to the legislative branch, and the legislative branch knows that they're working in collusion, in cahoots with the executive branch to violate all of these norms. So they don't care if there's a separation of powers problem because they have more power if they're unified. And they can create these pseudo-prosecutorial committees to go after their political opponents. And the emasculated Republican Party will just sit there and not do anything about it. And they know it. That's why they've been doing what they've been doing. So Trump's lawyers say the committee's improper purpose was not lost on the executive branch. Treasury rejected the committee's request as having an illegitimate purpose in May. It noted that the request was the culmination of a long-running, well-documented effort to expose Trump's tax returns for the sake of exposure. Treasury, this is the executive branch now, they're pushing back on this for now. They say Treasury highlighted the widespread contemporaneous acknowledgement of the committee chairman and other members of the committee, saying that the actual objective is to use the IRS as a means to expose the tax returns. Now, collecting over 40 pages of public statements, Treasury told Chairman Neal that his stated purpose was, quote, at odds with what you and many others have repeatedly said, which your intent is to publicly release Trump's tax records. Treasury, which is, this is interesting. Treasury actually pushed back on the committee and they said there is an objective mismatch, even though the district court said that it was totally legitimate. Treasury, this is wild. You've got the executive branch, which is the Treasury Department. You've got the judicial branch, which is, of course, the courts. And you have the legislative branch, and they're all stepping all over each other here. The legislative branch says we have the power to do this. The executive branch says, no, you kind of really don't. That's the Department of Treasury. And then you have the DC Circuit saying, yes, Congress, you do. Now it's going up to the Supreme Court. Treasury says that they wanted files from ongoing audits and they focused on a single president, even though most of the requested categories have never been publicly released with respect to any president. So they're filing, we want everything. We want all the documents, everything from beginning to end. Don't even think twice, just give us everything. And Treasury says, we've never given you that before. We didn't give you that for Clinton or Obama or anybody. And now you want all of that? And you're doing it for a legislative purpose? Okay, you liars. We have 40 pages of materials that say otherwise. Treasury further noted that the request does not inquire about the IRS procedures for presidential audits. And it doesn't ask for additional information about whether they've changed over times or anything. So accordingly, Treasury determined that it's not authorized to fulfill the committee's request. And the DOJ reached the same conclusion. So you can see that. Well, now that is back in 2020. That's before the DOJ. All this has changed now. The DOJ has changed into the Biden people now. In a June 2019 memo, the Office of Legal Counsel concluded that the request represents a culmination of sustained effort for more than 2 years to get those documents. The Office of Legal Counsel found that the committee's stated purpose blinks reality. It's pretextual. No one could reasonably believe that the committee seeks 6 years of a single president's tax returns because of a newly discovered interest in legislating on the presidential audit process. Yeah, very convenient. It further noted that back through 2017 and 18, Chairman Neal and others offered many different justifications for these actions, but never oversight, is what they said. They made clear their intent to acquire Trump's tax returns, and they concluded that those were not appropriate. Many of the requested documents were barely relevant to the audit process, and they were perfectly tailored to expose Trump's tax returns. That's all they wanted. But then we fast forward a little bit now. We get to July 2019. Committee sues Treasury and other government defendants to enforce its requests. Okay, so the people who are in charge right now, I sort of crisscross timelines. So let me just back up. I was crisscrossing timelines when I was ranting about the Biden administration and the DOJ and the FBI and the executive branch colluding with the Congress. That rant is not applicable yet. Right now in the timeline, we're still talking about July. Trump is still in office. It's still the Trump DOJ. It's still the Trump Department of Treasury. And none of that has changed yet. But the committee is the Democrats. They're in charge of Congress in July 2019. And so you can see now, right, until the balance of power shifted, we had the committee was not getting what it wanted. Treasury said no. This is ridiculous. You just want Trump's stuff. Same with the DOJ. Obviously, they're Trump executive branches. This is the separation of powers where you have both co-equal branches pushing back. So you don't get that stuff. But when the Democrats really, really wanted it, they sued. July 2019, they sued Treasury and other government defendants to get those records. That case was stayed pending resolution of another case, and it remained stayed for 6 months after Joe Biden took office. The new administration said, well, we have to figure out how we want to respond to all this. In July 2021, the government reversed course. Did anything happen? Did anything happen between July 2019 and July 2021 that would have caused the government to reverse course, right? In July 2019, Department of Treasury says, this is an overbroad, ridiculous request. We're not giving it to you. Same with the DOJ. It says this is a separation of powers issues. We're not giving it to you. You guys are insane partisan hacks. Get out of here. But Biden takes over. Now it's the Biden DOJ. Now it is the Biden FBI. It's the Biden executive that is okay with handing this stuff over because they don't care about the separation of powers because they're on the same team. The government reversed course, Biden's president. It informed the district court and the applicants that Chairman Neal had updated his request for Trump's tax returns. Yeah, he wanted the same information from the earlier years, and since he resent it over, Trump's not in charge anymore. Guess what? The government said, we'll comply. They said, sure, yeah, no problem at all. We'd love to give you those records. We can't believe it took you this long to ask. In fact, we're compiling them right now for you. Thanks for bringing it up. The government then revealed a brand new OLC opinion, a new Office of Legal Counsel opinion. It just changes. Can you believe these stinking lawyers out there? Ridiculous. Suddenly, new lawyers, Biden's lawyers, they look at this thing and they say, well, that prior opinion was entirely wrong, contradicting its 2019 opinion. The new 2021 opinion did not deny the committee's long campaign to expose President Trump's tax returns to the public or retract its previous conclusions. Instead, it simply concluded that despite all evidence, Treasury had to accept the committee's stated purpose at face value, right? Treasury has no choice but to disagree with what the legislative branch said. If the legislative branch says for 20 years they hate Trump and they want to see him fall off his roof, and then on that last day, they say, and also we're studying rooftops. That's all they need. They go, oh, well, they're studying rooftops. So that's all the evidence they need. Some lawyer in the Biden administration came out and said, perfect. That's it. Now, the Treasury just has to accept it. That's their new policy. Okay. And perhaps thinking the case was over, Pelosi candidly celebrated the government's reversal. Pelosi came out, she's like, yeah, not because the House could now study the presidential audit program, right? She didn't come out here and say, finally, we're going to get to the bottom of this. You know, we've had a very difficult time auditing all of these presidents. And now that we're in charge, we're going to fix the border. We're going to fix the economy. We're going to fix inflation. We're going to solve that. We're also going to solve presidential audits because holy moly, it's like herding cats with these guys. No, she didn't say any of that. Instead, she said, quote, the American people would now, quote, know the facts about President Trump. Oh. applicants, meaning Trump, immediately answered the committee's original complaint and filed counterclaims and cross-claims. And now they're suing each other or filing claims against each other all over the place. In its ruling, the district court, the lower level DC circuit, they recounted Chairman Neal's statements and they concluded. They said, yeah, I mean, they're relevant. Yeah, I mean, what he said about going after them is, yeah, they're relevant. And yeah, they do undermine the alleged purpose. And yeah, there is evidence that is improper, that is impressive, and yeah, it is troubling. But they say that the allegations of an invalid purpose should survive on the motions to dismiss. The district court dismissed all of Trump's claims, and the district court declined to apply this court's test, and instead used a different standard. Okay, some legal things here we've talked about, Nixon versus GSA. And the district court said that they only need to state, see this here, a valid legislative purpose. So if they want Trump to fall off the roof, if they say, we'd love to see him fall off the roof, I can't wait to it, snow is going to happen and America needs to see it, blah, blah, blah. But we're studying rooftops. As long as they stated that, there's a valid legislative purpose and they're good. DC Circuit says that's it. Perfect. Trump appeals, goes up to the DC Circuit Court of Appeals. Guess what? They affirmed. Yeah. They said, yeah, no, that sounds right. That sounds perfect. If they just say anything, it's good enough for us. Unlike the district court, however, the panel purported to apply the Mazars test, which is the test that the Supreme Court issued earlier. Nevertheless, it agreed with the district court that it was required to ignore all of Trump's allegations establishing an invalid purpose, saying that it could only consider the purpose that Congress identified in the request itself. We sort of talk about the four corners of a document in the law, four corners of this box. So they're saying that there's four corners here. If Congress writes the implied reason right in that box and they submit it, we can only look within the four corners of the box. Trump says that's ridiculous, okay, because they're a bunch of liars and everything outside of the box has said that they want to come after me personally in order to expose me and allow the American people to see this, that, or the other, and all of the other pretextual or all of the other actual reasons. The pretext is the audit. With this highly deferential review, the panel accepted Congress's, quote, need for this information without regard for other sources, rather than enforce Mazars' demand that a request be no broader than reasonably necessary to support Congress's legislative objective. The panel did not analyze the request's sprawling breadth. So what we're talking about here is a relationship between what Congress is demanding and asking for and the legislative purpose of Congress. Okay, so in this case, they wanted everything. They're making the argument. They wanted 6 years of returns and audit files. They wanted business returns, which are not even subject to presidential audits. They didn't even give us any guarantees of confidentiality of anything. Instead, they demanded detailed and substantial evidence. They ignored Trump's evidence of pretext, and they didn't assess the burdens imposed by the request at all. So the lower court didn't actually follow the test that was established by the United States Supreme Court. Supreme Court came out in a prior case, the Mazars case, and they said these things have to be correlated. You can't just go and ask for everything you want. You don't get a giant menu and you say, I'll take one of everything. No. If you want that, you need to show a direct correlation between why you need that bit of information and what you're going to do with it legislatively. And it should be no broader than reasonably necessary to support Congress's legislative objective. But they didn't do that. And the Supreme Court is saying, or Trump's lawyers are arguing to the Supreme Court that the Court of Appeals didn't follow those rules. They say, hey, Supreme Court, you said it's got to be reasonably necessary and connected. They didn't do that. They just said, well, if it's in the four corners of the box, it's good enough for us. They didn't look at the breadth of the request or how expansive it was. They didn't consider the burden at all. They just said that the request was only tolerably inconvenient and a possible but not a substantial threat to relations between the political branches. Trump's team says the panel thus reduced Mazar's scrutiny of the legislative purpose to a magic words test. Outstanding. Love that. A magic words test. Approving the request so long as the committee mouthed some permissible justification. Beautiful. Beautiful. Love that. Woo, love that. The magic words test. IRS audit. Is that good enough? Does that work? You got it. Yeah, bingo. You got it. Bingo. IRS audit. Perfect. You get all of Trump's tax records. Congratulations. Yeah. Magic words test. And so now you'll see that was the facts in the background. That was some of the procedural history. The rest of this is going to be some heavy lifting, which we always like to sort of really skim through. Reasons for granting the stay. We know that there are certain rules that courts have to sort of jump through. Does this apply? Yes. Does this apply? Yes. Does this apply? No. Therefore, no. And in order for the Supreme Court to grant a stay, which is to stop the IRS, stop the Department of Treasury from transferring these materials over to the House Ways and Means Committee. And as we saw previously, they want this to happen like now, right? They want all of this to be transferred very quickly. And so they're going through this. They're saying, look, Judge, there's a reasonable probability that 4 justices are going to consider this issue sufficiently meritorious to grant certiorari. Okay, so at least 4 of you people on the Supreme Court, when you hear the rest of this, you're probably going to want to hear this case. Therefore, you should grant a stay right now because it's likely that you're going to hear from us again. A fair prospect of this court is going to vote to reverse the judgment below, saying it's a 6-3 court. Probably likely you're going to reverse this underling court. And there's also a likelihood that, Judge, if you don't reverse this, there's going to be irreparable harm to Trump, which is accurate because his records will ultimately be released, right? That is exactly what they've been threatening to do. The Court of Appeals gave him permission and they say, we're going to do that. So, Judge, if you don't do these things, it's going to be a big problem. In close cases, please balance the equities, weigh the relative harms, and let us know what you'd like to do. They say the court should enter an administrative stay pending the disposition of the case. And they give us some more details and they flesh out each one of those bullet points with, you can see a lot of heavy legal lifting. A lot of this stuff, when you see a bunch of parentheticals and a bunch of italicized and a bunch of quotes and id, we're just going through case law and they're just sort of showing the court their authority and why it applies. And so as we fast forward through the rest of the case law, let's take a look at the conclusion before we wrap it up here. It says that, well, we're still going here. And nearing the end of this, let's get to the concluding paragraphs. We're talking about equities. They say that the public has a strong interest in avoiding the dangers of intrusion between the branches. If one branch is allowed to intrude on the other branch, there are problems. And so accordingly, Trump's defense and his application to the Supreme Court lawyers, they argue, they say, we respectfully request the Supreme Court enter in an administrative stay that is granted pending the filing and the disposition of a full petition for a writ of certiorari, or else consider this to be the petition, drafted and respectfully submitted by William S. Convoy and Patrick Strawbridge, lawyers out of Arlington, Virginia. Submitted into the United States Supreme Court, landing on the desk of John Roberts, the Chief Judge. John Roberts grants Donald Trump's request for a stay. You see a very short order coming out of the Supreme Court of the United States. Donald Trump versus the Committee on the House Ways and Means over there in the House of Representatives. Trump submitted a big motion. He said, this is going to be a big problem, Judge. Please do not allow the IRS and the Department of Treasury to reverse course, shatter the separation of powers, and transfer my tax documents over to a partisan hack committee of Democrats. It would be a big problem if you did that. And Judge Roberts, the Chief Judge, ordered as follows. Upon consideration of the application of counsel for the applicants, meaning Trump, it is ordered that the mandate of the United States Court of Appeals for the District of Columbia Circuit is hereby stayed pending further order of the undersigned, meaning me, Judge Roberts, or of the court. It is further ordered that a response to the application be filed on or before Thursday, November 10th by noon. So you can see something very interesting is happening there. That's going to be after the election. Curious. So it doesn't seem like they're going to get those records over to the committee before the election takes place. Oh man, they must be so mad right now. They almost got it in, just barely. But no, it's going to be pushed out until after the election. Oh man, they must be so upset. Isn't that just the worst? But that is the order from the Supreme Court. John Roberts is going to be awaiting the response by the U.S. government, and they're going to fight hard to continue to send those records over to the Democrats. But by the time it all happens, the election may be over. And if the Supreme Court moves quickly, well, one outcome may be that records don't ever get transferred. The other would be maybe they do get transferred. But the question is, do they have the time before the balance of power changes and the Republicans take over the House Ways and Means Committee? We, of course, will continue to follow. I hope you join us on that journey as we do. Don't forget to subscribe wherever it is you're watching this. And of course, thank you for liking this video and joining us on our next segment. All right, my friends. So that's the big update on Trump. Now, we've got some more election news because there's this DOJ is sort of inserting itself into this threat, apparently, of ballot watchers. We've got these ballot watchers in Arizona who are causing a lot of people to be concerned out there. And we see the DOJ is now trying to step in and make their voices heard. And so we'll talk about this. The Department of Justice meddling yet again in elections. Now, what we see is that they are concerned about Arizona ballot monitoring. You see this photograph here of two gentlemen sitting in a truck outside of an Arizona ballot polling location, and the DOJ just submitted a statement of interest. And so we don't really know exactly what that means or what they are intending to do with this, but they are sort of hinting that this could be an area that they're concerned about, that they may want to charge somebody with crimes if they continue to do this observation. Now, we don't know exactly if they're going to be filing charges or anything, but this filing is a mere statement of interest that is sort of hinting that they may have some issues with what they are seeing. Now, I want to show you this news report from local news here in Arizona that highlights a little bit more about what's going on. You can see that there is a lot of election concerns right now. We have these two gentlemen who are in the back of a pickup truck. You see police officers are over here on the far left. They are monitoring the ballot boxes. And we don't know if they're hinting at the DOJ that this is going to be considered to be election meddling or election interference, or if they're hinting that it could be. We'll have to see, but we're going to take a look at the DOJ statement of interest in a minute. First, though, let's get the background from the news.
Outside an early ballot drop box in Mesa, Arizona, two men armed, wearing tactical gear, watching voters. A vigil taking place over multiple nights.
Hi, guys.
One woman, a Phoenix area grandmother, decided to confront them.
Okay. Hey, don't touch me.
Why did you decide to go out there?
I'm standing up and pushing back against those people and standing up for everybody's right to vote. You don't mind if I set up right here, do you? Without fear of retaliation or any kind of intimidation. Hi, how are you?
She asked we not show her face because she did this.
What'd she do?
Right up in the armed man's face.
You know, I don't talk. I take care of business. I go out there and I do what I have to do. Nice to meet you. I push back against these kind of people who are intimidating voters.
No, he's spitting that in my face. I'm sitting down. He's with a gun standing over top of me.
And I'm standing up and pushing back against those people and standing up for everybody's right to vote without fear of retaliation or any kind of intimidation.
I'm just sitting here. I'm not even communicating with them. I'm sitting right here.
You know, seeing that, you would think you were in, some autocratic nation.
Autocratic
not
nation.
the United States of America.
And not the United States of America is what she said. And so the DOJ, of course, submitted a statement in a case, which we will take a look at. But we also have the docket, which we need to attend to. So let's get our bearings straight and see what this looks like, because it's a little bit complicated here. So we've got the DOJ. We have a number of different lawsuits that are being filed. And I want to just show you one that consolidates all of them. So we have this one right here. It says Arizona Alliance for Retired Americans versus Clean Elections USA. And Clean Elections USA is being sued. And if you remember, several years ago, we talked about a lot of litigation that was brought by retired Americans. Arizona Alliance for Retired Americans. Many of these organizations are being operated, in my opinion, by people sort of organized under the strategic guidance of Marc Elias, who we're going to hear from in a minute. He was responsible for, Michigan Association of Retired People and many others, or at least I think Democracy Docket was, or there's this big sort of group of them who are all involved in this type of litigation. The point is, this is one set of litigation that's taking place. And I want to show you that a complaint was originally filed by the Arizona Alliance for Retired Americans against Citizens for Clean Elections, the organization allegedly behind some of this poll watching stuff. There were motions that were filed. There were declarations in support that were filed by the plaintiffs, Arizona Alliance for Retired Americans. Okay. So they're all saying, yes, this is threatening us. This is scaring us. Please stop this. Tell Clean Elections USA to stop. Summons get issued over to Clean Elections USA, and the judge orders some hearings to take place. We have status conferences. We fast forward with more declarations. We have more hearings. Now you can see this is all happening just in the past couple of weeks. We're in October now, October 25th. Court provides notice to people. We have notices of appearances being entered on behalf of Clean Elections. So they're responding. They've lawyered up. We've got more declarations from people saying, I've been threatened. I've been intimidated, blah, blah, blah. Now we get closer to the election. We have minute entries. We have service being executed. A lot of activity for just a very short, a very recent case. But we're arguing about whether or not these individuals can continue to sort of monitor these ballots, these ballot boxes. And we finally get appeals and we get an order from the court. So I want to go through that. There was a hearing that took place in the United States District Court, and we'll go through that now. Order from a federal judge, Arizona Alliance for Retired Americans versus Clean Elections USA, the people allegedly responsible for the ballot monitoring that the DOJ is not happy about, that they're trying to sort of share their statement of interest with us. But the order came out from the judge that sort of says that they're not doing anything wrong. Here's the order out of the United States District Court for the District of Arizona. The judge writes the following. Earlier this year, filmmaker Dinesh released a movie. In it, he made arguments about electoral issues. The film prompted Melody Jennings to organize under the banner Clean Elections, a group of Arizona citizens to monitor 2 early ballot drop boxes in Maricopa County. That activity includes surveillance, photography, video recording, social media. It's alarmed voters, elected officials, and elections personnel. It's generated national media coverage, and many voters have filed official complaints with the Arizona Secretary of State and even sought law enforcement assistance. All of this prompted the Arizona Alliance for Retired Americans and Voto Latino, I thought it was Latinx now, is that not right? To file a federal lawsuit saying that Clean Elections and Jennings violated the Voting Rights Act and the KKK Act. They say that the election is right around the corner and we need prompt judicial action in order to handle this. The judge writes as follows. Says, okay, the 2020 election was very contentious. There was a lot of debate over what took place there. There were issues where people were talking about drop boxes. In the last several days, and let me stop here for our YouTube censors. Okay, nothing in this video that I am talking about is intended to imply that there is widespread fraud or anything that changed the course of any outcome or election ever. Okay, our election system is perfect. Nothing's wrong with it. Trust the CDC. Everything is fine. I have to say that for just to be extra safe on this, right? This is the judge writing this. This is a federal district judge in Arizona who is writing this. So let me friggin' go through it. All right, thanks. He's over there. I can see him getting squirmy in his chair. I'm like, will you just take it easy? I'm going to do my best on this thing. Relax. Gosh. All right. In the last several days, 3 separate Maricopa County voters filed formal complaints relating to voter intimidation near the drop boxes. Both drop boxes are in parking lots and they're positioned to allow voters to deposit ballots from their vehicles in a drive-up style. The first complaint alleges that a group of individuals gathered near the Mesa ballot drop box and photographed and accused the voter and his wife of being problematic. The voter alleges that individuals got in their vehicles, briefly followed them, and took photographs of their license plate. Okay, this is the judge writing now. The second complaint reported that individuals took photographs of a voter and his vehicle's license plate while depositing mail-in ballots. The third complaint described a group of 5 or 6 men standing in a Mesa Dropbox parking lot taking photographs as well. In these formal complaints, the sheriffs showed up. They were dispatched. They were there to investigate the armed and the masked observers. They were wearing body armor. All the while, Miss Jennings used her social media account to publicize the work and recruit others. Now, the judge tells us that a party that's facing irreparable harm may seek a temporary restraining order, and there's all these rules that apply in order to get one. But the judge walks us through standing, and let's see where this goes. He says you can only really bring a lawsuit if you have proper standing, and this is what standing looks like. The court here finds that Arizona Alliance has established standing for itself. Oh. As its injury, Arizona Alliance showed that the defendant's conduct requires that it has to divert its financial resources. And so we do think that they have standing. However, Voto Latino does not have standing. Voto says that it may need to expend considerable funds, but they have not. Therefore, court is going to dismiss it from the case. So Voto, you're gone. Now, they transition and they talk about the success on the merits. And, you know, if the court is going to grant a stay and say that clean elections has to stop all of this stuff, it should probably be because they're going to win, right? Like, you don't want to interfere with something that they're probably going to lose. And so the Alliance for Retired Arizonans is saying we're going to win this, but the judge is now analyzing that section. Here, the judge says the plaintiffs are arguing that clean elections have violated the law by intimidating individuals. But determining what constitutes intimidation is left to the courts, as that term is not defined by the law. And so the starting point is we got to go look at the language itself. We have to decide, what does intimidation actually mean? You're saying that it's intimidation. They say that they violated Section 11B through acts of intimidation. Okay, what is intimidation? Is it sitting outside in the back of your pickup truck? Is it just taking pictures, writing down license plate numbers? Well, we don't know. Well, if you're suing them to tell them to stop doing something, you kind of got to show why it's a violation of the law and why the court should grant a remedy for you. So, because it's not well defined, they got to go look to the statute. Judge says, therefore, the dictionary definitions of intimidate and threaten are instructive. We'll just look in Webster's, baby. What does it say? Intimidate means make timid or fearful. Okay. Or to inspire or affect with fear. All right. Especially to compel action or inaction as by threats. That is being cited by Webster's Third International Dictionary back from 1966. We don't need new modern garbage definitions of whatever language they're speaking these days. We're going to the 1966 edition, okay? Threaten means to utter threats against or promise punishment, reprisal, or distress. We got some definitions now. Importantly, any definition of intimidation must account for rights established in the Constitution. And we've got a lot of legalese here explaining that. As the court finds it, they say that the people bringing this lawsuit, their primary aim, the primary objective here, is to put an end to clean elections, Dropbox surveillance activities. They don't want you out there taking pictures and photographing them. So the judge says, okay, I understand that there's a lot of stuff you want, but you want them to stop this thing. This requires a free speech analysis because it implicates free speech rights. Not all of the defendants' challenge conduct involves traditional speech, and the mere act of poll watching is not a fundamental right that carries its own distinct First Amendment protection. The judge is citing other case law. The judge says the critical question is whether a reasonable observer would interpret the conduct as conveying some sort of a message. Any type of a message. Would it convey a message? Judge continues, says, the evidence in the record shows that the poll watcher's objective is deterring supposed illegal voting and illegal ballot harvesting. Ms. Jennings, her social media post demonstrates that she believes the presence of her volunteers alone would convey to these messages to supposed ballot mules, they say. The message is that persons who attempt to break the Arizona anti-ballot harvesting law will be exposed. On this record, therefore, the court finds that a reasonable observer could interpret the conduct as conveying some sort of a message, regardless of whether the message has any objective merit. Okay, so it is a message, which means we're talking about speech now, right? It's a message. Additionally, it's well established that there is a First Amendment right to film matters of public interest that comes from the Ninth Circuit, 1995. Supreme Court recognized a right to gather the news, 1972. The public has a First Amendment right to receive information and ideas, 1980. The First Amendment goes beyond protection of the press and also goes to individuals to prohibit the government from limiting the stock of information that members of the public may draw, right? The government doesn't have a right to information, public information. You also have a right to that. 1969. So the judge says, well, having established that the conduct at issue here is subject to protections of the First Amendment, given the fact that it is speech, the court must analyze whether there's any exceptions that apply. Plaintiffs argue that true threats, right? If this is a true threat, First Amendment doesn't apply. Judge said, yeah, that's true. That is true. But a true threat needs to be something more. Even a statement that appears to threaten violence may not actually be a true threat. And they give us several examples of this. And so they write that the plaintiffs, the people who want the ballot monitoring to stop, have not provided the court with any evidence that the ballot watchers constitutes a true threat. Nothing meets that definition. On this record, the ballot watchers have not made any statements threatening to commit acts of unlawful violence to any individual or group. There's no evidence that the watchers have publicly posted any voter names, home addresses, occupations, or other personal information. In fact, Jennings continuously states that her volunteers are to follow the laws and that those who choose to break the laws will be seen as an infiltrator intent on causing harms. Jennings' social media posts also admonish volunteers to remain outside the statutorily prescribed 75-foot voting location radius. And furthermore, the record contains evidence of Jennings' social media post instructing her affiliates not to engage with or talk to individuals at the drop boxes. Even if those statements are mere window dressing, a reasonable listener could not interpret Jennings' social media pronouncements that alleged mules will, quote, shrink back into the darkness as true threats. Also, the ballot watchers' conduct does not fall into any traditionally recognized category of voter intimidation. Other examples where it has reached that level are provided for us. And the court details what those look like. But here, there is no evidence that the voters using the drop boxes are primarily minorities or that they have historically been victims of targeted violence. Taken together, the court cannot conclude that this is a true threat. Just don't see it. The court has struggled to craft a meaningful form of injunctive relief that does not violate the First Amendment rights. So you're asking us to get rid of these people. They're there following all of the rules. They are not doing anything that constitutes a threat, according to the judge. And you want us to just get rid of them? Okay, well, you got to show us why. And if I were to craft a remedy, how could I possibly thread the needle so I protect their First Amendment rights and deliver what you want as well? I don't know how to do that. The court acknowledges that the plaintiffs and many voters are legitimately alarmed by the observers filming, but on this record, they say the defendant's conduct does not establish a likelihood of success on the merits that justifies this relief. They give us a little bit about the KKK Act. The court says, for these reasons, they say your claim is not going to succeed on the KKK Act, okay? There is no serious question going to the merits of the Klan Act claim, okay? Nice try, Marc Elias. But it's not going to be good enough. Now, irreparable harm is another element because the Democrats are saying if this is allowed to continue, well, the election is going to be thrown, right? This, and you, my friends, they're going to say this was voter suppression to the end of the day, okay? Voter suppression. Our people couldn't vote because of this. Just wait for it. They're saying that we are going to be irreparably harmed. Judge, if you do not stop these people from monitoring these ballots, irreparable harm to Arizona. Judge says, well, on that issue, it's well established that interference with the right to vote is irreparable injury. And there's examples of this. If the electorate suffers intimidation, yeah, that is irreparable harm. But in analyzing this factor, the court does not assess the likelihood that such a harm will occur. Should the defendant's alleged intimidation dissuade voters from exercising their rights, they will be irreparably harmed. They say that's true. But the court does not consider the likelihood of this occurring, and so that factor tips in favor of the plaintiffs. But we also balance the equities. So he's giving some different factors. He actually gives that to the plaintiffs, but also has to implicate First Amendment considerations if he imposes an injunction. An individual's right to vote is fundamental, but so too is an individual's right to engage in political speech, to assemble peacefully, and to associate with others. U.S. Supreme Court case 1966. Saying there is practically universal agreement that a major purpose of the First Amendment was to protect the free discussion of governmental affairs, including the discussion of candidates, structures, forms of governments, the manner in which the government is operated or should be operated, including elections, and all such matters relating to the political processes, protected, authorized by the Second Circuit in the year 2000. We're allowed to talk about elections in this country. We're allowed to ask ourselves about voter enfranchisement, interference, meddling, all of that stuff. We're allowed to talk about it. Now, we got to be very careful about it here on YouTube to say it didn't change the outcome of anything. And so I'll reiterate that again. But it is something the Supreme Court has said, you're allowed to observe and monitor and participate. And all of those examples are listed in this order from the judge. They say that the plaintiffs have failed to provide the court with a narrowly tailored injunction that would avoid sweeping protected activity. Overly broad. They say the parties implicate rights equally crucial to the functioning of our republic, and we have a strong interest in maintaining them. Thus, the court finds that the balance of the equities and the public is neutral. Okay, so the judge is kind of analyzing both factors. In conclusion, the judge rules, plaintiffs here, the retired Arizonans, have failed to show that they're likely to succeed on the merits. While there are serious questions implicated here, the court cannot provide preliminary injunctive relief without infringing on core constitutional rights of free speech. Further, while the irreparable harm factor tips in favor of the plaintiffs, the balance of the equities and the public interest do not. A preliminary injunction cannot be issued on these facts, but Arizona Alliance is invited to return to this court with new evidence that the defendants engaged in unlawful voter intimidation. Therefore, It is ordered denying the plaintiff's motion for a temporary restraining order, meaning the ballot watchers can continue to watch away, granting plaintiff's motion for leave to file notice of additional authority, meaning they can come back and submit more materials, directing the court to dismiss voto Latino out of the case, and saying the case is still open pending further materials, signed by Michael T. Liberty, United States District Court judge. So a big ruling on that. And of course, the Democrats are very unhappy about this. I want to show you this little clip from Marc Elias. After that ruling, he came out and he was unhappy. Democracy Docket founder Marc Elias, many people call him the purveyor of all of the election litigation responsible for many Democratic victories in 2020 and beyond. We see that Marc is upset that the ruling went the way that it did. Democrats did not want the federal judge to allow the ballot monitoring in Arizona to continue. But now that the judge has ordered that it can continue because those people have free speech rights as well, Marc Elias says, we're going to sue your butts if you continue to do it.
Obviously, like many people, I was quite disappointed by the decision. The First Amendment does not grant people the right to intimidate voters. First Amendment is not a blank check to stake out ballot drop box and try to demonize people who are voting through a legal way that is authorized by Arizona law. The First Amendment is not a gun to be held to the head of democracy.
They're not holding guns to the head.
So we filed an appeal with the Ninth Circuit, which is the court that oversees the district court in Arizona. Last night, we filed a brief seeking an emergency stay before that court, and we will see where we go from there. But what I can say to Republicans and conservatives that if you intimidate voters, if you engage in unlawful acts of voter suppression, you will wind up in court.
Nobody's arguing that. Nobody's encouraging voter intimidation or voter suppression or illegal activities, Mark. These are people who are just sitting out there, just watching. And there's not a whole lot of problems going on with our elections. They're perfect. Okay, I'm confirming that here for YouTube and everybody out there. Our elections are perfect. There was anything wrong with 2020. 2022 is going to be perfect. I disagree with Hillary. I don't think that the Republicans are going to steal 2024 either. It's perfect. We've reached the end of history on elections. And so these people who are just sitting out there, just watching the ballots being counted and dropped off, I mean, they're not going to see anything problematic. And since elections are so secure, it's certainly not going to suppress or dissuade anybody from going there, right? Of course not. Oh, of course not. No, it's all going to be perfect. But Mark is saying the obvious that, yes, if you go out there and you intimidate people or you interfere with them, yeah, you might actually be charged with a crime. We've already got laws on the books there. But that's not what Clean Elections is doing, is it? No, in fact, a federal judge, said it was all, as far as he could tell, being done above board. A little different, not exactly the same thing that we're used to seeing, but also not illegal. And Mark is very unhappy about that. Wonder why that might be. I don't know. I don't know why he'd be upset about that. The Department of Justice is also weighing in on this. Now, I said at the beginning that this is where they are sort of getting involved. Some people might call it meddling or trying to put the thumb on the scale. Let's take a look at what they filed in a companion case, because that came out here. They submitted this. Let's see what the Department of Justice submits a statement of interests of the United States. Very unhappy with the Arizona Ballot Monitoring. They submitted this in a 25-page filing coming from the Civil Rights Division from the voting section. What's the DOJ doing now, getting involved in election ballot monitoring when there's no criminal charges that are involved? Civil rights are here. They say that they've got a lot of things to say about this, about Section 11B, and how this prohibits intimidations and threats and coercion, and that people who use mail-in ballots and drop boxes should be protected. And we'll see what their conclusion says. But they're submitting this right before an election. They don't like what's happening in Arizona. Very contested race is taking place here. And let's see what the DOJ has to say. The United States respectfully submits this statement of interest pursuant to the law. The United States has a substantial interest in ensuring proper interpretation of the law. They say the United States expresses no factual issues, no view on any factual disputes. We're only talking about the law, about 11B, right? So we're not actually going to see anything about the ballot monitors. But why are they filing this? And I forgot to mention, this is not in the same case. So if you look at the case header, this is in League of Women Voters versus Lions of Liberty. And you're saying, what? That's not what we're talking about. We were just talking about clean elections, Arizona. So it's a different group. But I think I also failed to mention that they were consolidated. So you can see here, this case is consolidated with this case. The clerk of the course is going to consolidate that case number along with this case number, along with this case number. All future cases are going to be smashed together. Okay, so it's not just one organization who's out there doing this and who's being sued. Many organizations are out there doing this, and many other organizations are filing lawsuits. And so the DOJ is submitting this in a companion case, which is being processed sort of in parallel because the judge is consolidating them. All right, so let's take a look at what their arguments are from the DOJ. They say this case alleges that organized and sometimes armed group of individuals have engaged in campaigns to surveil, video record, and harass voters as they exercise their most fundamental right, the right to vote. These allegations raise serious concerns of voter intimidation, which of course is proscribed by the law. Now, 11B broadly prohibits this. They say that it's wide ambit for both violent and nonviolent conduct. Polling place conduct, like private surveillance and investigations, would ordinarily intimidate voters and has little purpose. They say it all has to go. They say First Amendment rights can present protections, but we also have to understand the crafted limitations. A little bit of background here. This is from the Department of Justice. They say, as a statement of interest to the court, according to the allegations of the plaintiff here, the League of Women Voters, defendants Lions of Liberty, Yavapai County Preparedness Team, and their members have commenced a widespread campaign to surveil all drop boxes in Yavapai County, and then report to law enforcement any voters who deposit multiple ballots. They say that is despite Arizona law permitting individuals to deposit multiple ballots in certain circumstances. Okay, so we're going to get into a little gray area here. The complaint also alleges that Clean Elections USA, or CEUSA, and its founder, Melody Jennings, intend to publicly reveal information online if they peddled that information. According to the complaint, they guarded these drop boxes, and the defendant says that these tactics are already deterring voters from using drop boxes. So the government, of course, is just stating their interest. They're not a party to this. They're not filing a lawsuit. They're not acting on this. But the DOJ is making their position known. So we don't know what the next filing will be. Okay, this is they're in other words, they're drawing the line in the sand. They're saying this is our interpretation right now. This is how we're interpreting this. So if we start seeing any of these organizations doing any of this stuff, guess what? You're now on notice. Court granted the motions, consolidated a bunch of cases. We've already gone through some of the statutory background. We know they're talking about Section 11B of the Voting Rights Act. And that section says, no person, whether acting under color of law or otherwise, shall intimidate, threaten, coerce, or attempt to do any of those things when it comes to voting. Pretty generic stuff there. So they go through the statute, and a lot of this is going to be boring legalese. Again, a lot of heavy lifting here. Southern District of New York from 2021. They're taking apart that statute, and they're saying, well, what does intimidate mean? Well, what does threat mean? And they say, well, it could mean economic threats. Legal action could be a threat. Dissemination of personal information could be a threat. Surveillance could be a threat. And they're making their argument that all of this falls within the purview of that law. Other things that could be problematic, anything that obstructs, accosts, questions, targets discrete groups of voters based on identity, and those things are problematic, right? And this is their argument. And a lot of it's sort of heavy lifting. So we'll fast forward through it and see if we can get to a conclusion from the DOJ. And we saw the judge basically threw that argument out. So they're appealing this to the Ninth Circuit, and I'm sorry, they are appealing this to the Ninth Circuit. We heard that from Marc Elias. And we'll see what the Ninth Circuit does. But they say, in conclusion, the United States respectfully submits this statement of interest to assist the court in evaluating these claims, signed by Michael E. Stewart, Kristen Clark, Gary Restaino, over from the United States Department of Justice, submitting this just to let everybody know, that, hey, we think that this is how the law is interpreted. And if you do something differently than how we think the law is interpreted, well, you might be committing voter intimidation. And we know what the DOJ does with this crap. So if anybody out there is involved in any of this stuff, be extra careful that you're following the laws and that they're like to a T. Be very careful about what you're posting on social media, because in my opinion, this is them putting that out there. They're saying this is what we intend to do. And if J6 and any of these other, efforts or any indication of what the DOJ does to people that they consider to be threats to the democracy, they could be turning the microscope down upon these organizations and entities. And this just may be what they're running up the flagpole to let everybody know. So be very, very careful out there if you're out there protecting the democratic process, because the DOJ is salivating. I can feel it in this motion. I can just feel it. Statement of interest. Next thing that will come will be criminal charges. So extra cautious out there. But that is the update, my friends, on the Arizona ballot monitoring saga. Marc Elias making threats. The DOJ making threats. They don't want you looking at those ballots for some reason, whatever it is. But election season is here. You can see they are trying to make sure the process goes the way that they want to. And we'll continue to cover this as it heats up. Thank you for subscribing and following along wherever it is you're watching this, and I look forward to seeing you on the next one. All right, my friends, and we've got one final segment left that we have to get into, and I got to pick up the pace here a little bit because it's Tuesday, and we know it's Men's Group Tuesday, baby. All right, and so let's get right into it. Finally, the media seems to be acknowledging that there is a red wave incoming. We've got RealClearPolitics, 538, that Nate Copper Silver guy. All of them are saying that it may not be good news for the Democrats. You can see a couple of new graphics and images coming out from RealClearPolitics and 538. Let's take a look at both of them. Oh, that's not what we wanted. Here is what we wanted. A new map from RealClearPolitics shows Republicans looking pretty dang good. Estimates saying 54 to 46 might be the outcome, with the GOP picking up 4 additional seats. Some of the ones that might flip: we've got New Hampshire, Arizona, Nevada, and Georgia, all Senate races that are looking very, very, very close. And this was something that got sort of tighter as the days went on. And it sort of shifted. Many of these states used to be blue. Now they are looking red. And we have just a couple days until the election takes place. We'll see if they get any redder. But it's not just RealClearPolitics. RealClearPolitics is sort of an amalgamation of a bunch of different polls, including, you see here, what they're referencing for Fetterman, Hassan, Kelly, Mark Kelly, and others in all the various states. But if you look at 538, you see the same thing. Nate Silver at 538 reports Republicans are 51 in 100, likely to gain control of the Senate with just a single vote to put them in the majority. Democrats looking like they may end up with 49 out of the 100. And the Nate Silver poll is always interesting because you see how the dynamic changes as the election gets closer and closer and closer. So here we have, back in June, we saw that, things were pretty close. The Democrats look like they may keep control. Republicans look like they may keep control. But then the Democrats had this big fat balloon over the last several months. And I've always had a lot of questions about why this happens in polls. Why do we typically see these big, big fat wins up here? Democrats likely 70% to keep the Senate. Now it goes to 68%. And then suddenly, when we get to like mid-October, It goes from 65% likely to win or to hold the Senate in October 16th all the way down in just a couple weeks to the Republicans are now going to win 50-50. Yeah, just a couple weeks. It just shrinks like this. It goes whoop, all the way down. Why does that happen every year? Is it because there may be an attempt to get people in the early voting portion of the elections to join in on the bandwagon effect? Is it because they want everybody in this era from July to October, everybody in that couple months who starts voting, to just vote for the bandwagon, vote for the people who are going to win? All of those millions and millions of votes going out there, all probably going for the bandwagon. And so I wanted to spend a quick minute on that. Why do we see that every year, everywhere we look? It could be that the polls are accurate, that the polls are following the actual reality of the public, and they're actually tightening as the race gets near. I don't know. Maybe that's true. It could be that the polls are misinfo, that the polls are just wrong in general, and they don't know what the heck they're doing. And sometimes they get closer, but it's unintentional. Or it could be because they are intentionally inaccurate, that they are trying to tighten the polls now because they want to fake like they have credibility after the elections are completed. But regardless, it seems like there's always these big, big swings. And if I had any guess, it'd because I think that they want to create a bandwagon effect and encourage people to jump on the winning team while the early voting is taking place. Then once early voting is over, they go, oh, now we can start showing reality because they've already got a big bank of votes that have been settled for them. But it is not looking good for the Democrats. Democrats are way down in the polls. It's looking like a red wave is going to reverse power, and we have to check in with the president. While the Democrats' chance at holding Congress evaporates, President Biden takes advantage of that big October surprise, Pelosi's de Papi over there in San Francisco.
I want to make a brief statement about Nancy and Paul Pelosi. You know, talk to them. He seems to be doing a lot better. Looks like he's going to recover fully. And but also, don't know for certain, but it looks like this was intended for Nancy. He kept asking, where's Nancy? Where's Nancy?
Where's Nancy?
And the generic point I want to make is that, you know, it's one thing to condemn the violence, but you can't condemn the violence unless you condemn those people who continue to argue the election was not real, that it's being stolen, that all the malarkey that's being put out there to undermine democracy. You can't just apologize and say the violence. It affects people's mentality. It affects how people think, particularly people who are not maybe as stable as other people. So the talk has to stop.
The talk has to stop. That's
the problem. That's the problem.
Yeah.
You can't just say, I feel badly about the violence. We condemn it. Condemn what produces the violence. And this talk produces the violence.
The talk produces the violence. If you say anything in this country that is dangerous, you're responsible for the violence. In fact, if you question anything, it sounds like you might be contributing to the MAGA insurrection that took place in Nancy Pelosi's home, and it has to stop. It has to stop. It's not enough to just condemn violence. I mean, if you condemn violence, that's like halfway there. But you also have to do everything else that we want you to do because we're the Democrats and you have to do what we say. Otherwise, you're condoning political violence. So the big October surprise is we're seeing if they can use that to their advantage. But it doesn't look like it's going to do anything really consequential. The polls are just way too down in the dumps. But the White House is not going to let it go easily, trying to milk as much as they can out of the Paul Pelosi de Papi saga. Karine Jean-Pierre is trying to castigate the entire Republican Party, blaming them all for the violence just because they disagree with the Biden administration's politics.
We have to condemn political violence. It is something that should not be controversial. It's something that should not be partisan. It is something that all of us need to say that, and it should be done in one voice. But sadly, it has become political, and we need to end this. This is what the president has said multiple times, and he's talked about it in his speeches and in his remarks. And the thing that is probably the most
Biden has talked about it in his speeches and remarks. He's called the entire Republican Party extremists. He stood at the gates of hell in front of a red backdrop where he was making his MAGA murder speech known to America, threatening all Americans by saying the MAGA Republicans are going to take away your economic security and your personal liberty. That's the president. That's the person who is incentivizing people to, according to him, by using his speech to go out there and commit political violence. But this guy, David DePape, is not even somebody who is a right winger. We covered this at length yesterday. We had DePape's neighbor said that he's pretty sure he's a lefty. They support all sorts of lefty causes. They had a rainbow flag outside of their house. They had BLM flags. They were supporting all sorts of nudist efforts in the hills of San Francisco. So what the heck is she talking about? And look at that freeze frame. Perfect freeze frame. Let's just let that linger there for a minute.
Haunting about when we hear the reports of this assailant, of the attacker that we were speaking of, is that he was yelling out the things that we heard during January 6th, which is, where is Nancy?
Oh, gosh.
And, you know, again, we need to end this type of.
Could you write that any better? Like, honestly, if you played one of those games where you have to like come up with a bunch of words and you're like, insurrection version 2.0, it would definitely be like Pelosi. It would definitely be skull. It would definitely, work in J6. Hammer would be a great addition if you could add the word hammer in there. It's like, wow, that's a hammer, skull, Pelosi, mansion, break-in, San Francisco, J6, MAGA, insurrection. Amazing. That's perfect. Go ahead. Go deliver that, Karine.
Rhetoric, it needs to stop, and it is incredibly, incredibly dangerous.
Well, listening to you makes me wonder, has the White House, has the president reached out to, say, Senate Minority Leader Mitch McConnell, House Minority Leader Kevin McCarthy, in an effort to get everyone together and put out a bipartisan condemnation or statement about the political environment we're in and tamping down the rhetoric?
Oh gosh, tamping down the rhetoric. Listen to these people. It's so hard to talk with the potential of crazy people breaking into the speaker's house. This story is the weirdest story.
So a unified show of force against what we're facing.
Well, as you know, you interviewed the president most recently, and he believes in reaching out to the other side and working together, and that is something that you see throughout his career.
Yeah, he wants to reach out and work with the MAGA extremist insurrectionists who are going to steal your life and liberty away from you. Got it. All right. So while they are trying to squeeze everything they can, wring everything out of the Pelosi to Poppy Hammer story, Biden is out there on the campaign trail trying to sell a last couple of votes. Joe Biden broke news. He told us today that unfortunately his son died in Iraq, which I never knew.
And they talk about inflation. We're dealing with it for a whole second. Inflation is a worldwide problem right now.
That's true. Thank you.
The war in Iraq and the impact on oil and what Russia's
doing. Wait, what?
The war in Ukraine.
Oh.
And think of Iraq because that's where my son died.
Oh.
Because he died. But the point is that that's why it's up. We have the lowest inflation rate of almost any major country in the world. We've done a lot to try to take it under control.
So I guess Beau Biden, who died of brain cancer in, I believe, Maryland, apparently died in Iraq also. One more time.
Problem right now because of a war in Iraq and the impact on oil and what Russia's doing. The war in Ukraine. And think of Iraq because that's where my son died.
No.
Because he died. But the point.
Because he died. So I think he tried to correct himself. My gosh. So yeah, we're not in a war with Iraq. No, your son didn't die in Iraq. He served in Iraq. He died of brain cancer in Maryland, and may he rest in peace, and hope your family is well over that. That sucks. But it is not quite reality. So inflation is not caused by him, not caused by his billions of dollars, trillions of dollars that he spent. None of that is his responsibility. In fact, Biden did the opposite. Deluded President Joe Biden says that he actually cut the deficit in half. He sort of forgets about all of that COVID money that both parties printed. He said that because we stopped the COVID money, he's cut the deficit, when in reality, he hasn't done anything close to that at all. The lies continue. This is the president.
Let me say something. I want to point something out. They talk about big spending Democrats. Yeah, I spend a lot of money to do these things, but guess what? I cut the deficit in half.
Wrong.
In half, the federal deficit. This year alone, $1,400,000,000 reduction, $400 billion.
400.
Reducing the debt.
400,
last
400
year,
billion.
$350 billion reducing debt. Give me a break. I'm so sick and I shouldn't get going.
You shouldn't get going, Joe.
Come on, man. I mean, it's just amazing. No, that's a fact. As my granddaughter used to say, Google it. You know, I'm serious.
Google it. All right. So you can go ahead and Google that, and you can see if he's being honest with those numbers. In other words, did he cut the deficit to pre-pandemic level? Did he cut it by half to pre-pandemic levels? Or is he taking that number from the height of all the COVID pandemic where they shut the whole world down? Because we're not going to have to do that every year, Joe. We're not going to have to pay out trillions of dollars because we locked Americans in their homes. No, not going to have to do that ideally. So why are you taking credit for that? It sort of sounds like a little dishonest, doesn't it? And but that's just what he does. Now, we've heard from Karine, we've heard from the president. They're constantly screaming about unity. This is Joe Biden saying he really wishes he could work with Americans, in particular Republicans, to get things done. If only those stupid, unenlightened idiots would get it.
There's nothing beyond our capacity if we set our mind together and work together. So God bless you all.
Yeah.
God protect our troops, and God give some of our Republican friends some enlightenment. Thank you.
Joe Biden, I'd love to work with you. God bless America. God bless all of us. We can do this together. There's nothing better that we can do. This is America, but if only those stupid moron Republicans, those unenlightened troglodytes, those idiots could just get it. Well, Biden says he's not holding his breath, so I guess we'll just have to use the DOJ and the FBI to eradicate them on his way out as he's lowering costs for American families with his continual mismanagement. Meanwhile, we have to check in with the vice president because there's a lot going on. While the country nears an election, Americans turn to the vice president for guidance. Can she navigate our country through the storm? Can she solve some of America's most pressing problems? The vice president has a plan and a solution, and she's excited about it.
I love Venn diagrams.
Oh, great.
I really do. I love Venn diagrams. It's just something about those three circles and the analysis about where there is the intersection, right? Yeah, I see people,
Right.
You agree with me, right? So, okay, so I asked my team, I brought props.
She brought Venn diagrams, something like incompetent, idiot, and cackle. You put the three circles over each other. Where does she fall in there? It's Kamala. Yes, there's an overlap between incompetence and cackling, and idiocy and cackling. And she's sort of, I mean, I don't know that you can come up with anything better than that. We've got the vice president solving America's problems with Venn diagrams. And I'm excited to see what she comes up with. Hopefully it solves all of our problems. Yikes. All right. But that's what the White House is doing. Lion Ted Cruz responds that if the Republicans win, things are going to be a little bit different. That if they take power and win control of the Senate and the House of Representatives, there will be some aggressive oversight incoming and America will be restored to glory.
Yes, I think we're going to take the majority, a big majority in the House, 30, 40, 50 seats. In the Senate, I think we win between 53 and 54 seats. I think we've got a great chance to win in Nevada, a great chance to win in Georgia. I think we've got really competitive races in Arizona and New Hampshire, and I think we've got a real shot in Colorado and Washington State. All of those are in play. and I think we're winning in all of the vulnerable states. I'm very excited. When we have the majority, you can expect aggressive and real leadership and oversight.
Aggressive.
Thank you, Senator. Good to see you. We'll be right back.
Aggressive and real leadership from Ted Cruz, saying if the Republicans are in charge, maybe they'll form their own committees. Maybe they'll take it to the Democrats and get some oversight. Only time will tell, but your vote matters this time. And so go make sure you are participating in the tremendous red wave that many of us are expecting as the election nears. We'll continue to cover it. It will not be over on Tuesday. There will be a lot of litigation and battling. I'm sure of it. We will continue to cover it. Thank you for joining us as we do. And thank you for subscribing and following along wherever it is you are watching this. I look forward to seeing you on the next one. All right, my friends, that is it for the segments. Woo, we covered some serious ground today. We have a little bit of time left, which is perfect. Red wave incoming. We covered that. Not looking good for the Democrats, but looking good for America. That's nice. DOJ sort of issuing some threats, kind of getting in there and, kind of turning the knobs on some of this election stuff. And they filed a statement of interest in that case. We have Trump having a victory at the United States Supreme Court, Democrats not getting his taxes. At least they're not getting released before the election. The judge, John Roberts, actually stayed the order ordering the transfer over, and we're going to cover that and a whole lot more. And I appreciate you joining us as we continue to do that. But now, my friends, it is time, before we head over to watchingthewatchers.locals.com for the extended show after party. We're going to continue on here for a little bit. Let me make sure that I can say thank you to everybody who sent in those very generous super chats. I saw a couple of those come in. A very generous one in particular came in from our friend Zulu in the house. And of course, I've got to log in, because this is just how it goes. Anytime you do a show, it logs you out. Even though you log in before the show starts, it just still does that because that's just what YouTube does. All right, and so we are scrolling over to that. I've got to do some finagling on my end in order to make this functional for some reason. Did you know that did you see the YouTube's change? Right? They sort of changed the whole layout. I'm not sure what you guys think about it. The red YouTube button is not even a thing anymore. It's a little bit weird, isn't it? Yeah. All right, but I think I've got the appropriate tabs open now so that we can say thank you to those very generous super chats that came in. And we had two of them. Zulu, with a big generous one, says, please accept these 2 modest loads of groceries as a token of appreciation for this knowledge venue. That's from Zulu. Zulu, first of all, that is an extremely generous super chat. Thank you for sending that in. And number 2, that's a very nice message. Knowledge venue. Well, thank you for that, Zulu. I got to tell you, I learn a ton from you guys, and I'm constantly scrolling locals and sort of getting feedback from you in real time, sort of paying attention to the chats, keeping my eye on everything. And I'm grateful to go through all of this with you, honestly, right? I sort of feel like this is a two-way symbiotic sort of thing that happens here. And I'm really grateful to be a part of it and share this time with you. And I mean that genuinely. It's really a lot of fun. I feel like I learn a lot myself by having to do the show. It sort of forces me to compress a lot and become, better, more knowledgeable, synthesize things faster. And then I get to share it, get feedback from you in real time. I think we're going through important topics, and I think we're having some fun while we're doing it. And Zulu, I'm very grateful for you, my friend. I appreciate you being here. You've been here for a long time, and I am grateful for your support. And I mean that genuinely. So thank you for it. And very generous of you. And 2 loads of groceries. I mean, I'm not sure what you eat there, but, that's, 2, like you can squeeze 2 out of $100. It's pretty good. You've got that down. I feel like the grocery bills are, it's like $150 easily now. Like a gallon of milk is like $11.50. It's ridiculous. All right. But thank you, Zulu, for that. And I really do appreciate it. I know it is a lot. It is expensive these days. Thank you for being here. We have another one from Curtis. No question on that, but Curtis Bartle sending in a super chat. And I'm grateful for that one as well. And so thank you, Curtis Bartle, for sending that one in. Let's say hi to our friends over on Rumble. We're also on Facebook now, by the way. I'm not sure if you're anybody's watching over there. If you are, drop something in the chat so I can see it and say hello to you. But over on Rumble, we have shout outs to Anything. We've got Bastiat, Sedona Rocks, Perambulator is in the house. Along with Bastiat, Sedona Rocks, we have Candy Gas. Vienticus Prime is over there as well. And yeah, the Rumble is sort of picking up play. Hey, George Klaus is in the house. Hey, George Klaus, we were just talking about you. George Klaus is the fine craftsman of the Gavel of Justice. Shout out to George Klaus. We were just talking about George. That's awesome that you're here. All right. And so I think that is what we've got for the show, my friends. We are going to leave it right there. We're going to come back and we're going to go over to locals actually for about 10 minutes. It's Tuesday, so we have to wrap things up here so I can get to my men's group. But I want to thank you for being a part of the show. If you want to join us for the after party, for the morning walk and talks, and for great community, it's over at watchingthewatchers.locals.com. Come on over. We have an awesome, the water's great. Come jump on in. And a lot of it is free, right? A lot of this stuff, like you don't even have to pay anything. So if you want to join the after party, it's free. Just come over and hang out. We're not going to make it members only. If you want some of the other stuff, I do put some of it behind a paywall, but a lot of it is totally accessible. So come check it out. Also, I am a criminal defense lawyer. And so, we have a ton of fun on this show. We do some heavy lifting, but every single day we have an awesome team of lawyers at the R&R Law Group. Not just the lawyers, everybody's incredible, who help good people charged with crimes. Every day we work with dozens of people across hundreds of courts in Arizona, and we help them get through their difficult times. And we'd love to be able to work with you as well. Phone number is 480-787-0394. Only if you need it. We don't want you to get in trouble to work with us, but if you need it or know somebody that does, we have an awesome team. We're very passionate about the work that we do. I was just out of town for a bit, and so we had some awesome meetings yesterday and today with the team, sort of getting back in sync on a couple things, and I'm just super excited about the work that we do. Your referrals keep us busy, and I appreciate them, whether it's online at rrlawaz.com or at 480-787-0394. We very much appreciate your referrals. They keep us busy, and they keep us with time to spend here together. And so thank you for thinking about us. Shout outs to the mods who mod down the fort for us. They go out to Vienticus, to K Bean in the house. We've got Just Cause. I saw Leans over there. Zulu, of course, was here playing hooky. Ronnie Cole was out there. I say Just Cause. I already got Just Cause. Yeah, I just saw Just Cause again. Shout out to Just Cause and others who swing by from time to time. But that, my friends, is it for us on the day. We are going to leave it right there. We'll be back here tomorrow to do it all again. Same time, same place, same location. We're heading over to locals right now for a few minutes, and I hope to see you there. But if you're not there, then at least come back here tomorrow so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Have a tremendous evening, my friends. I'll see you right back here tomorrow. Bye-bye.